Where's my friend? Where did he go? Oh, there you are. Nick, can you see my mask? You're muted.
Looks like a Texas Rangers.
Oh my God. You who wanted to go to a Mud Hens game said that. So, good morning, everyone. How are we all doing? Well, yes?
Good morning. Doing well.
Good morning, Steve. Rocky, congratulations on the, I didn't realize you were chairing the I-Court.
Yeah, I had some extra time, so
I
I
bet
thought
you
I'd get
did.
involved in that too.
Wow, that's tremendous. So I did your survey. I hope I'm not going to be, yeah. Even though the chief sent me another email, do I have to do it again?
No, she sent that out to everybody, so trying to get the get this information in so they start analyzing it before our next meeting in December.
Yes. So I know Pierre is going to be attending by phone. John Martin, I see. Justin, tell me how we're doing.
I'm on, Gene.
Oh, you're staying.
It's no. I'm on the phone. Just
Oh, you are on the phone. Yeah, I see that.
Yeah.
No.
Okay, perfect.
Very good.
Judge, the only people that are not logged in that have not indicated they would not be here are Sheriff Riggenbach and Andy Wilson.
Okay.
A few others, Representative Leland won't make it, he said, and
Representative Leland and the OPD Tim Young both have legislative session to attend to, since our GA is awfully busy right now. So we only have those two. DA Krasner is getting some paper. He'll be right back. The only other business that we have to handle today would be the minutes from our last meeting. We can do that, and then I can introduce our two speakers and allow them then to begin their presentation once the DA Krasner comes back. So has everyone had a chance to review the minutes from our last meeting? And is there any comments, questions, concerns that those minutes have raised with any of you? If not, could I have a motion by a raise of a hand for adoption of those minutes? Okay, Judge McIntosh, thank you. A second? Judge Navarre, thank you. All in favor signify by raising your hand. Yes. All right. Any opposed? Same sign. Passed unanimously. Thank you. That takes care of that. Tricia, how are we doing?
I am good, and I'm glad you just turned to me, Judge. I'm going to run away for about a minute. I'm going to go grab a pair of glasses. I'm realizing I'm having difficulty seeing the screen, and I'm embarrassed to admit that. All right. I'll be right back, okay?
All right, and your boss just returned, so we'll wait for you to return, and then we'll turn the program over to you. All right?
Hopefully it'll be 1 to 2 minutes. I'll be right back.
All right. So DA Krasner, are you a baseball fan?
I have been. Depends on how busy I am.
Are you more Cardinals or Phillies?
I am more Phillies, having grown up mostly in Philadelphia from about the age of 9. But I do.
Oh, is that when you moved? Okay.
Yeah, but I do remember being in the car when my dad and his brother were driving to Busch Stadium to see, I think it was Cardinals Tigers World Series. This must have been
1968.
Yeah, that sounds about right. It was just before we left for Philadelphia.
That was one amazing series. So Denny McLain, 31 game winner.
Yeah, that was a great team.
Last 30 game winner in baseball.
Bob Gibson.
Gibson.
Kurt Flood.
Yep.
Yeah.
Lou Brock.
Lou Brock. That was an amazing team.
All right. Patricia is back in less than 2 minutes for the record. Excellent. So I want to, this is a special meeting of the Conviction Integrity Task Force, and I want to particularly thank the District Attorney from Philadelphia, Lawrence Krasner, who has agreed to present today. He and Patricia Cummings, who is the supervisor of the Conviction Integrity Unit for DA Krasner's office. Just brief bios for each, and we'll send all of you a more formal bio so you have that for your records should you care to review. Patricia actually comes to Philadelphia by way of Texas, where she, I think you grew up there as well as went to school there, worked extensively in a number of pro bono and law-related positions in Texas, most notable as it relates to our work in looking at Conviction Integrity Unit, helped run the Special Field Bureau Chiefs to lead the Conviction Integrity Unit in the Dallas County District Attorney's Office. If you remember John Holloway, who presented last time for us, he describes Patricia as the first free agent in conviction integrity work, having been hired by DA Krasner to relocate from Texas to Philadelphia once DA Krasner was elected as the 26th District Attorney for the city of Philadelphia. He had been an attorney of counsel in a firm, and prior to that time spent a lot of work as a public defender and doing public defender work in the Philadelphia area, as well as on the federal public defender office in Philadelphia. So he comes through this issue as a practitioner on the defense side. I think this was your first office that you ran for, was it not, DA Krasner, this DA office?
Well, I ran in student council and lost, but other than that, yes.
Statute of limitations run on that one. So
I was second out of two, so there you go.
Ran in 2008. Well, actually ran in, what is it, 17, because you run in the off year cycle. Correct. And was elected as the 26th district attorney. And I am very much appreciative of each of you willing to take time out of your busy schedules in Philadelphia. Glad that you could carve out a little bit of time and present to us about the success that you've had and the process that you have employed in implementing and I think fully integrating what a vibrant conviction integrity unit can look like, to give us some background and some perspective. As agreed, what we're going to do is we're going to turn the program over to Patricia and to DA Krasner. They're going to jointly present. It's about a 90-minute presentation all in or so. And then after that, we'll take questions. So if you have questions throughout, let's write them down if you want to put them in chat, and we'll organize them. But they want to, because they're going to do an interactive presentation, we'll let them present, and then we'll inquire of them thereafter. Okay? The floor is yours. Thank you very much. Welcome.
Thank you so much. My name is Larry Krasner, DA in Philadelphia. I want to do something that is not so technical, but I think it's important because I understand how sincere the task force is about addressing this issue. And I know that you don't want to waste your time, and that your intention is that if you do make recommendations or you're trying to achieve some kind of change, that it is something that would be effective. I have no doubt that, as in Pennsylvania, when there are creative and modern ideas about prosecution, that you may come up against a prosecutors association. And I don't say that to in any way be disrespectful to them, but we've withdrawn from the Pennsylvania Prosecutors Association, and we did so because we had to do so. Our philosophy and policies were wildly at variance with theirs about half the time, not all the time. And what they were doing, because we were members of the group, is they were lobbying the legislature, saying, the whole prosecutors organization agrees, when our jurisdiction actually constituted 40% of their membership. So we were being hijacked in that way. And I am afraid the truth is a lot of statewide prosecutors associations currently are set against where the people are. The people are pretty clear that they want progressive prosecution. They are pretty clear that they want to have a level of police accountability. And we find ourselves, and I say this as someone who's a very strong supporter of labor and has a lot of labor support, we find ourselves in a situation as progressive prosecutors, and I am one of them, where we feel like we're a lot closer to the active membership of the police department than we are to their union. And I feel like progressive prosecutors who are being elected all over the country in increasing numbers, most recently, the largest criminal justice jurisdiction in the United States elected a progressive prosecutor, and that is Los Angeles, California. There have been 24 progressive prosecutors elected around the country in this cycle. There were 4 losses. So that should give you an indication as we go cycle to cycle that it is not a fluke. It is not an anomaly. What is happening is consistent with what we see in the polling that I have reviewed, which is there's a genuine appetite among voters in the United States, and it's not all by party lines. There's actually quite a bit of conservative support for this. There's a genuine appetite for modern approaches to criminal justice and prosecution. And there is a sense that we can do better. We definitely can do better. So I say all of that to get at whatever you're going to be able to accomplish here is going to require communication with prosecutors and people who support prosecutors in ways that will allow you to achieve it. I think one of the things they don't understand at all is that conviction integrity is not a one-sided endeavor. It is the flip side of the coin of solving cold cases. It is the same thing. It is a fundamental belief in the accuracy of the system. And it goes very directly to why anyone would want to be a prosecutor. I do think that there are prosecutors who, because of the nature of the job, perhaps forgot the joy that they felt initially in wanting to do this thing. And that joy has to do with accuracy, and it has to do with truth, and it has to do with representing everyone, even if that person happens to be an innocent person sitting in a jail cell. So I want to talk to you about how we talk about this. I want to talk a little bit about the joy that I find as a prosecutor in this, where it comes from. And I think once you have figured out the nuts and bolts, and there is no one better in the United States to talk about the nuts and bolts of conviction integrity than Patricia Cummings. I hope you'll do things like ask her questions about the police misconduct database, which is it's a close cousin of conviction integrity, because I think you'll find some pretty startling, interesting things. But I want to try to speak to you in a way that will perhaps convey to you the joy that I find in conviction integrity and why I think that prosecutors should not be fearful of this. They should embrace this. We have even seen another prosecutor in Pennsylvania embrace this, and honestly, perhaps for political reasons, when that prosecutor saw how popular it has been in Philadelphia across the board, when we have very carefully, thoughtfully, and honestly exonerated a number of people because that was justice and that was the right thing to do. Even people who were more political than we are decided, hey, this might be a good way to go because it seems like the voters want it. So let me just talk then, if I may, for about 25 minutes, something like that, about how I would try to communicate this. And I hope that there's something in there of use beyond the nuts and bolts to figure out your pathway to achieving what you're trying to achieve. So in my mind, a prosecutor's oath includes a commitment to uphold the Constitution and laws, and above all, to seek justice. Nothing in that oath limits the obligation to the future, to seeking justice moving forward in time, although obviously that is crucially important. The oath applies equally to cases from the past as it does to new ones. Some legal scholars and many traditional prosecutors emphasize finality, the importance of a conviction being final, with no further litigation allowed forever, as if the systemic and bureaucratic convenience of not looking back is paramount. It isn't. Finality and the prosecutor's oath to seek justice collide when crimes remain unsolved or when innocent people remain in jail. Prosecutors must solve and prosecute cold cases. Prosecutors must exonerate and get people out of jail whose convictions lack integrity. It's a heavy obligation to fix injustice in the past and in the future, especially when those involved are still living. In a perfectly just world, that obligation to seek justice would go on forever. Innocent people deserve their reputations back, even if after they are executed or die in jail. Guilty people who escaped accountability deserve the ignominy they avoided in their lifetimes, commensurate with their crimes. Even as an unattainable ideal, the commitment of our justice system to correct its mistakes, to constantly try to do better, is essential to public trust, which is at the core of a functioning system. And we do not have enough public trust between police and the communities they serve, and between prosecutors and the communities they serve. In 2019, within a few months I met two different men for the first time. One was exiting prison after 28 years spent in custody for a terrible crime he did not commit. The other was entering jail after 28 years of freedom, despite the terrible crime that I believe he committed. The men in their cases are opposite sides of the same coin. They are the tragedy and the triumph of justice deferred but achieved. When I first met Theodore Dill Donahue, I was watching him through the darkened lenses of my sunglasses in a sun-drenched parking lot at the State Police Barracks outside of Philadelphia on the day of his arrest in 2019. It was 28 years after I believe he committed the crime. He was a stout 52 years of age, casually dressed in shorts and a summer shirt, with the light shining off his pale, bald head, squinting into the sun as state troopers escorted him from their van. His hands were cuffed behind his back. As troopers took him into the barracks, he looked over his shoulder at a news camera, and in a flat tone, he announced that he was innocent. For months, I had been hearing updates on the investigation of the murder of Donahue's one-time girlfriend, Denise Sharon Kolb, who moved into Donahue's apartment in October 1st of 1991, and was found a month and a half later in a shallow grave in a wooded area, half dressed, with the rest of her clothes piled on top of her body. 4 years before Dill's arrest and 24 years after the crime, a curious state trooper decided to revisit this cold case after decades of dormancy. In Donahue's original interviews from 91, he told police he was doing crack with Kolb on October the 18th, 1991, when they were robbed, and that Kolb ran away in search of help but never returned. But other members of the Kolb family said the Donahue story was untrue. Family members of Kolb had last seen Kolb and Donahue a day after his story, arguing in front of a bar. Phone records confirmed that there was a call between Donahue and Kolb on October the 19th, one day after Donahue claimed she had disappeared. And Donahue had hurriedly tried to return Kolb's clothing that was still in his apartment to her family right after her disappearance and before the body was found, for no apparent reason. Years later, Donahue's story changed under the trooper's questioning. Instead of claiming he and Kolb were using crack on October the 18th of 91 when he last saw her, he now claimed to have last seen her outside of a bar on the same date. He later told someone that she was found strangled in a shallow grave. But when he told this person that information, it was before her body had been discovered. Another source said Donahue kept a number of items that he called trophies from Kolb's death, which turned out to include a sock. That sock had its pair, and its pair had been found among the clothing in the shallow grave. The matching of the new socks was new, just like Kolb's revised story was new, accomplished with new capacities for photographic enhancement that were donated by a local university. Donahue also did an annual pilgrimage, it turned out, to a hotel near where Kolb's body was found on the anniversary of her death. But many of these specifics were not known when the original investigation occurred. Other discoveries suggested Donahue may have committed other crimes. Among Donahue's belongings, when he was arrested, police found an original police mugshot of a murdered woman who was not Kolb, but who had a criminal record suggesting drug addiction and sex work like Kolb. That photograph was a shiny black and white from back in the 1990s, a time when it would have been much more difficult to obtain such a photo from an electronic database. It certainly calls into question how Donahue could possibly have had this unusual access to police files and police mugshots. The email address Theodore Ted Donahue was using 28 years after Kolb's death was Ted Bundy 67. Ted Donahue was born in 1967, unlike the real serial killer Ted Bundy, who was born in 1949 and died by electrocution in state prison in Florida in 1989. The real Ted Bundy, prior to his execution, confessed to 30 murders as well as rapes and kidnappings. The actual number of his victims is probably higher and difficult to determine. By the time of his execution, the real Ted Bundy was internationally known due to his horrific crimes and his two successful escape attempts from custody, followed by lengthy manhunts and recapture, including one escape from a Colorado courthouse, every judge's nightmare, during trial, and another escape involving self-starvation until he was thin enough to get through an air vent in his jail cell. Bundy's highly publicized execution occurred only 2 years before Culp's killing, when Donahue was the impressionable age of 22 and involved in drugs by his own admission. When I first saw Donahue in that parking lot, he was a pizza delivery man and had been one for decades since Ms. Culp's death, and perhaps before as well. He had lived above a busy pizza parlor for many years called Golden Crust Pizza in Northwest Philadelphia. It is the most middle-class, affluent section of town. It's a bedroom community where I lived with my family for 26 years before becoming district attorney. He undoubtedly delivered pizza to my home before my kids went to college, likely several times. That was our Friday night routine. Golden Crust Pizza was their favorite when they were young, and he even delivered to their babysitters when my wife and I were out. Pizza delivery, like any other job that gets you onto other people's property, presents possibilities and it wards off suspicion. It's a ready-made excuse for being on strangers' sidewalks, for knocking on doors, for going past the same properties repeatedly, for surveilling and lurking. Donahue is in jail today awaiting trial for the death of Ms. Culp in Philadelphia County. It remains to be seen what the justice system makes of how and why Donahue obtained an original police mugshot for a similarly troubled woman who also died by murder, or whether Theodore Donahue's email moniker means something, or whether his work delivering food to strangers was a cover. But all those questions stand a better chance of resolution now that Donahue is in custody and charged with killing his girlfriend after 28 years of delay. Of course, that was 2019. That was also the year I first met Chester Holman III. When I first met Chester Holman, he was in my office being interviewed with 2 other exonerees by a television reporter. He'd been out of custody only about 35 days after 28 years inside. He was a fit and carefully dressed and groomed man who had been raised in church. When he went to jail, he had no criminal record. He was nearly silent, unassuming, and far quieter than his 2 exoneree companions who had been out of custody a year or more. They were smiling, wiping tears, talking about their lives and their future plans. They were farther along, the other 2, in their adjustment to freedom after their own decades in custody. Holman's eyes kept scanning his surroundings, still vigilant in a freer and less threatening world than he had known for a long time. After the interview, Holman and I were walking down the hallway outside of my office with the other 2 exonerees on our way out of the building, and with Patricia Cummings, by the way. I asked him how he was doing. He told me he was adjusting. He said he was afraid to sleep in darkness after almost 3 decades of sleeping in prisons where the lights were always on. An innocent man who endured 28 years in custody felt more danger sleeping at home in his own bed with the light turned off than he had felt sleeping under buzzing yellow lights in an unpredictably violent warren of cages where he was surrounded by convicted felons doing their own hard time. Unlike Holman, some of his fellow inmates had done real violence outside and inside the institution. Holman told me he still jumps whenever he hears something that reminds him of the sound of a cell door slamming. He said, excuse me, I have a bit of a cold. He told a reporter that he felt crushed inside after coming out of custody. He said he truly thought he was going to die in jail. Chester Holman III's nightmare started in 1991 when a South Korean exchange student at the University of Pennsylvania named Tae Jung Ho was murdered during a robbery in the early morning, a few blocks from the high traffic, affluent Rittenhouse Square area. 2 men robbed Tae Jung Ho. One of them shot him to death with a .38 caliber handgun before both men jumped into passenger seats of a waiting rental SUV that drove away. A gutsy cab driver heard the shot, chased the SUV, and noted its make and color, plus the first 3 letters on its license plate, which were AYZ. He quickly called the information in to police. Young Chester Holman was driving a rental car on the night of the killing, not far from the crime scene, accompanied by a young woman, Deirdre Jones, who was his neighbor. Holman's rental matched the description of the killer's getaway car in color, make, and in the partial description of the letters on the license plate. When an observant police officer stopped him, it made no sense that Holman was driving toward the crime rather than away from it. Even so, as far as the police were concerned, they had their man. After all, the car matched, including the first three letters of the license plate. AYZ were the first three letters of the license plates of 6 matching rental cars in Philadelphia available at the airport the night Tae Jung-ho was killed. All 6 cars were the same color and make. One day after the killing and Holman's arrest, Philadelphia police received an anonymous tip that 2 of Tae Jung-ho's killers were at a specific address in Philadelphia. The address was connected to a woman named Denise Combs. Philadelphia police visited the address, but when Combs said she had no connection to Holman, police disregarded the tip and focused on obtaining witnesses who would corroborate their case against Holman. Far too late, we now know how compelling that further investigation might have been. We know that Denise Combs had rented one of those 6 matching rental vehicles. She returned it to the airport only a few hours after Tae Jung-ho died, around 5 o'clock in the morning. 5 o'clock in the morning is an inconvenient time for most people, especially for someone like Combs, who was not taking a flight to return a rental car. In addition, we now know that Ms. Combs rented a lot of cars, including the one she rented to her brother a year before Ho died, that he used to commit a murder, for which he was incarcerated on the night when Ho died, and for which he remains convicted to this day. In an unguarded moment, Combs told defense investigators a few years ago that she once got rid of a .38 caliber gun, the same caliber that killed Tae Jung-ho. Combs explained she got rid of the .38 because it, quote, might have a body on it, unquote. But police in 1991 didn't know all of that and made little effort to find out. Rather than pursue the Combs lead because it didn't implicate Holman, police ignored it and they worked on tracking down witnesses against him. They succeeded in extracting 2 witness statements, one from a homeless man and another from Deirdre Jones, who was in the car with Holman. The homeless man, Andre Dawkins, claimed to be an eyewitness to the killing in 1991, only to recant 10 years later in 2001, saying he had been addicted to drugs at the time and was pressured by police to implicate Holman. The neighbor, Deirdre Jones, made a statement in 1991 that said she was in the car with Holman around the time of the killing when he and another man exited while she stayed in the car. Her statement said that she heard a shot around the time of Ho's killing. But by 2012, she sat in the witness box in court and tearfully recanted to a judge. She said she had been pressured by police to give the original false statement on threat of being charged herself. She said she had been haunted by her lies against Holman and their crushing consequence ever since. Misconduct directed at convicting Holman was not confined to egregious and illegal coercion of witnesses. Police and prosecutors concealed evidence they are required to provide to the defense before, during, and after trial, while Holman sat in a cell. The crucially important anonymous tip about Denise Combs was buried, concealed from Holman and his attorneys until he was released in 2018. And it was concealed until 2018, the year before he was released in 2019. Concealing the tip meant that from the time of his arrest in 1991 through 2018, Holman and his attorneys had no chance to pursue the lead and do the investigation the Philadelphia Police Department had dropped within days of Holman's arrest. The illegal concealment of the tip meant that Holman was doomed and that the real killers would go free, perhaps forever. It made little difference at Holman's trial that a good defense attorney had obtained the names of renters of the other rental cars. Yes, he could argue that there were other cars in Philly that night, but without the tip connecting one of those renters to the murder, Holman's attorney had no lead to spur further deep investigation of Denise Combs and all the people she knew. Even the mere fact that a tip about Combs being involved in the murder had caused detectives in Holman's case to go to the Combs address would have caught the jury's attention and would have suggested there was a reasonable doubt. The jury never heard that fact because police and prosecution hid it. The tip did not factor into the trial when Holman was 21 as a defendant. It remained buried when Andre Dawkins recanted in 2001 after Holman had done 10 years in jail. By then he was 31. He remained buried in 2012 after Holman, when the neighbor recanted, 21 years into his sentence, he was 42. It remained buried when an investigative reporter wrote about Holman's case in the Philadelphia papers in early 2017, while I was off campaigning for DA on a reform platform after 30 years as a civil rights and criminal defense attorney. Holman was 47. All those years, the tip remained buried by police and prosecutors who were sworn to follow the Constitution, which doesn't just suggest, but does require disclosure of information potentially favorable to the accused on guilt or on sentencing. They broke their oaths. Unlike Holman, police and prosecutors broke the law. The obligation of the state to provide information helpful to the defense, as you all know, is known as the Brady requirement from the name of the U.S. Supreme Court that requires disclosure. That is a special obligation prosecutors have, and police as well. It is not optional. Before we took office in our administration at this district attorney's office, we knew that the DAO, the district attorney's office, had what it called a conviction review unit for several years. It consisted of a chief attorney, an assistant attorney, and an occasional administrator. Rather than try to fix past injustices, the DAO's conviction review unit existed to protect the DA's office and its convictions from closer looks. Its existence was window dressing on an empty house. The single exoneration that occurred during its existence was not its own work. That exoneration came from another prosecutor and a different unit in the office who unearthed overwhelming evidence of innocence for a convicted man. That prosecutor's supervisor in that other unit didn't want his unit to be tarred for actually exonerating anyone. So that unit supervisor pushed it off on the conviction review unit to walk it into court and carry it out. After the conviction review unit's chief was moved along, hundreds of unopened letters from inmates claiming they were innocent were found in the conviction review unit's office with postmarks going back years. When asked about it, the outgoing chief blandly commented it wasn't his job to read their letters. Yes, it was. Our administration decided to hire the right people and give the unit a more honest name. First, we hired Patricia Cummings, about whom you have heard, from whom you will hear more. We knew that establishing innocence or guilt to a certainty is often an impossible task. Scientific certainty via DNA or other compelling forensics is ideal, but is not available in most criminal cases, including Holman's. Thankfully, it is available in more of the most serious cases, and those are the ones where we tend to see exonerations for a lot of reasons. The system recognizes that uncertainty is real in criminal justice and even dictates the conviction of people when there is doubt, so long as that doubt is slight and does not rise to the level of reasonable doubt. The existence or absence of reasonable doubt is arguably the jailhouse door. Reasonable doubt means the defendant gets to go home. But what if a reasonable doubt, or maybe a whole lot more than a reasonable doubt, shows up long after trial, even if there is no scientific certainty of innocence? What if, due to new developments, new evidence, old evidence that was hidden at trial, new scientific methods that were unavailable before, or new information that undermines witnesses, the conviction cannot stand because it lacks integrity? The answer should be that the conviction is reversed and the person who was convicted goes home. Integrity and an integrous system require it. In keeping with this standard, we changed the name of the unit from the Conviction Review Unit to the Conviction Integrity Unit. We changed the unit's capacity by beefing up its staffing with several more attorneys and staff members. We found people who had plenty of criminal justice experience, but who had no reason to protect any prosecutors or police whose convictions needed to be reconsidered. At this point in our administration, almost 3 years in, we are at, I guess it's 15. Maybe I lost track of one. Patricia, you can address that. but we are at about 15 exonerations with more expected in coming years. We have rejected far more requests for exoneration than we have accepted. I know that Patricia will correct this, and I invite that. Last time I checked, we were looking at about 4% of the cases that were considered had resulted in our supporting efforts for an exoneration. We get requests from the Innocence Project, from big law firms that bring us fat files. We get requests that are nothing more than a thin letter from an inmate written by themselves in jail. We open those letters. That's our job. Judges have carefully reviewed and approved all of the exonerations we have achieved so far due to certain aspects of Pennsylvania law that are not required everywhere. At first, before they saw the balance and care that went into our decisions on exonerations, a few judges were skeptical. A few judges resisted. For decades, the Philadelphia District Attorney's Office had been predictable for fighting against any relief for convicted people, including exonerations. They even fought, and I mean fought, against new DNA testing. But when judges saw our reasons and why the Philly DAO had changed its view on these cases, the specific facts and law that led us to our conclusions, those judges also changed. It can be overwhelming to handle all current and future cases while reconsidering cases that are unsolved and cases where the conviction may lack integrity, but it's our oath. Finally, let me just say this. I remember being in, I think I was in Chicago with a number of other progressive prosecutors. The prosecutor there was Kim Fox, and is Kim Fox, who has been reelected there. On that day in Chicago, they exonerated 15 people in a single day. She had been in office longer than me. Chicago is arguably the epicenter of false confessions, a place where what happened with the Central Park Five was sadly not uncommon. And part of the trajectory of what we see with really good conviction integrity units is that they begin by examining individual cases. And as they come to their conclusions in many individual cases, patterns emerge. In Chicago, what happened is that what emerged is that there were a few detectives who were prolific at taking confessions from innocent people. By the time you have multiple cases where DNA conclusively establishes innocence, and yet you have people who never even saw the crime scene, but are recounting all of its details in a confession. And on top of that, you have similar stories coming from defendants who never met each other or had the chance to communicate about how that false confession was extracted. By the time you have that, you have a red flag, and it's on the forehead of that detective. Not all detectives, because there are a lot of wonderful detectives, like there are a lot of wonderful cops, but those detectives. And it means that you have an obligation, if you take your job seriously, to examine all the homicide cases where there were confessions taken by those detectives, because you know there is a credibility issue. And so that is how it came to be that in Chicago, on a single day, 15 people were exonerated. It was a result of an exhaustive look at a few prolific homicide detectives who were most notable for extracting confessions from innocent people. It meant that all their cases had to be re-examined and considered with the following question: is there enough evidence to find this person guilty beyond a reasonable doubt without that confession? Perhaps that's a little bit of a rough articulation of the question, but I think you see my point. So there is a progress and there is an evolution with what these units do and how they do it. And I don't think there's anyone better at talking about the nuts and bolts on this topic, any more significant national figure in terms of conviction integrity units than Patricia Cummings, who has not only headed our unit brilliantly and in a way that has been very strong for its independence within the office, which is quite important, but has also done so in another city where some of the lessons learned have benefited us in Philadelphia. So I don't know if I'm supposed to introduce Patricia or someone else is, but I'll introduce whoever is introducing Patricia or Patricia. Thank you.
Judge, you're on mute.
I was on mute. I'm sorry. So Patricia, let's quickly segue to your presentation. So since it dovetails nicely with Larry's presentation, thank you, Larry, for excellent words. Go ahead, Patricia. Floor is
Thank you,
yours.
Judge. Thank you, Judge, and thank you, Larry. Let me say at the outset, I ran to get my reading glasses to find that they were not in my desk drawer. So hopefully I don't have difficulties when I get to my PowerPoint, but I just wanted to share that with you guys. It's an honor to be part of this conversation. I wanted to say hello to a couple of you guys, a couple of you I've worked with before, and it's really good to see you on this task force. Whenever I talk about this particular topic, I'm reminded of two of my favorite quotes from judges. The first one is a quote from Judge Learned Hand in 1923. I'm not so sure that people are as familiar with this one as maybe they should be, particularly if you're interested in this topic. But this was a case where Judge Learned Hand said, "Our criminal procedure has always been haunted by the ghost of the innocent man convicted. It is an unreal dream." The second favorite quote of mine is from Justice Felix Frankfurter in 1949. What Justice Frankfurter said in this particular case is, "Wisdom too often never comes, and so one ought not to reject it merely because it comes late." Both of those affect me on a daily basis, and they have been since I got involved in really what we've all called the innocence movement. I want to share with you just a little bit about that, and then I'm going to give you an overview of what I'm going to cover in today's presentation. One of the cases that I worked on starting in the early 2000s was the case of Michael Morton. And some of you guys may or may not be familiar of it. And I could spend 2 hours just talking about the case because it's that fascinating. What I will share with you about it kind of dovetails a little bit with some of the things that Larry has talked about. First, if you're not familiar with the case, I'm going to recommend that you check out the documentary about his case and his life. And it's actually called An Unreal Dream. And that comes from Judge Learned Hand's quote that I read to you. Michael Morton was convicted in the 80s in Texas of brutally murdering his wife. And from the outset, he always maintained that he was innocent. I got involved, as I said, in the early 2000s as a pro bono defense attorney helping the Innocence Project on their quest to try to prove that Michael Morton was innocent and to try to obtain DNA evidence testing to actually prove that he was in fact innocent. The amazing thing about that case is he ultimately was indeed exonerated, and he was exonerated based on DNA testing. And during the course of the work on that exoneration, a plethora of evidence was unearthed that established that the prosecution had Brady information that was never disclosed. Larry talked to you about the Donahue case and the Holman case and how that's affected him in terms of solving a cold case 28 years after the crime and then watching a man walk free 28 years after he was wrongfully convicted. Michael's case is very similar to me in my life. The difference is what happens in Michael's case kind of dovetails all into one. And what I mean by that is when Michael was exonerated, this perfect storm occurred because not only was it possible through DNA to prove that he was in fact innocent, that DNA actually told us who the real perpetrator was. And so in Michael's case, when Michael walked out of prison, within a couple of years, the person who actually brutally murdered Michael's wife, Christine, was prosecuted and prosecuted successfully, such that he is now serving a life sentence. And on top of that, DNA also linked that same person, Mark Allen Norwood, to a brutal crime 18 months after Christine Morton had been murdered. And Mark Allen Norwood was successfully prosecuted and convicted of that crime. And all of that is to say, his two convictions occurred almost 30 years after the crimes had been committed. When you get something like that, you cannot, with a straight face, ever say conviction integrity work is not important. Everybody who is a stakeholder in the criminal justice system has got to recognize that we make mistakes. And on top of that, we've got to recognize that we all have an obligation to take the steps necessary to remedy those mistakes. And because all of that happened in Michael Morton's case, justice was served. And as Larry said, it was deferred in regard to Michael Morton, but it was served. And it was deferred in the case of convicting Mark Allen Norwood of 2 brutal crimes. Michael Morton is really just the tip of the iceberg. We know now that those mistakes not only happen in Texas, they happen in Ohio, they happen in Pennsylvania, they happen all over our country. So with setting the stage with that, I'm going to go to the PowerPoint now and try to tell you guys what I hope to cover and then leave enough room so you guys are able to ask questions at the end of the presentation. Can you guys see the PowerPoint? Some of this, and I don't want to be repetitive, but I am going to talk a little bit about things that I know you already know about, not only because I'm aware of the work you're doing as a task force, but I'm also acutely aware of John Hallway and how he presents this issue. So I'll go through some of it quickly because it's really just a reminder, and then I'll focus on some of the areas, spending more time when I think it's something that may be relatively new to you all. So at the outset, I'll talk a little bit about identifying the problem and indeed say over and over again that we all know wrongful convictions occur. After I deal with that briefly, I'll then get to the question of how do you address the problem? And when you talk about addressing the problem, which is what you all are tasked with, I think you've got to go back to the basics and you've got to ask who, what, where, when, and how. And finally, the last part of my presentation will be solving the problem. And it will come as no surprise to you guys, given the fact that I have run a CIU in Dallas and now in Philadelphia, that I really believe that CIUs are probably the best answer we have for solving the problem on a nationwide basis at this time. The slide in front of you should be just kind of a rehash of things that you already know. And certainly, I think you guys know that so much of the information we have regarding wrongful convictions and exonerations come from the National Registry of Exonerations and their website. So as you can see, as of 1989, we have had 2,686 exonerations, and that's a significant number. I'm going to pause for a minute before I go on further because I want to make sure that whenever we are having a conversation or any of you are having a conversation with anybody about this topic, it's so important to make sure that when you're using certain terminology that you are defining it the same way, or if you're not defining it the same way, you have an understanding of how each other defines it. And specifically what I'm referring to here is exoneration. My experience in different jurisdictions have led me to really appreciate how people define it differently. For purposes of this presentation, I'm going to rely on the definition of exoneration as put out by the National Registry of Exonerations. Specifically, if you go to their website, you'll see that they've defined it as a situation where there is newly discovered evidence of innocence that has led to the vacatur, the reversal, and ultimately the dismissal of charges against a person who was convicted of a crime. The reason why I'm relying on that definition is because in Pennsylvania has not recognized legally in any forum that a person charged with a crime has a due process right to not be convicted if in fact they are factually innocent. I know Ohio has some definition of actual innocence, and it's a little bit different and probably more favorable than Pennsylvania. But sometimes when you're in jurisdictions that have recognized actual innocence, like Texas, for example, they define exoneration a little bit differently, because in Texas, you have a standalone claim where you can get relief if you've had a constitutionally fair trial, but yet you can establish by clear and convincing evidence that you're innocent. So in that situation, people in Texas would refer to when you've established the actual innocence, you're exonerated, and that ties into Texas compensation statute. So you have to establish that there's been some finding of actual innocence to get the money under the compensation statute. So I kind of go off a little bit because I think it's so important to understand that people are going to use different definitions for various terms. So having done that, now I'm just going to say, take a look at the slide. I know you've probably seen these numbers before, but it's quite awesome when we understand how many exonerations we've had, and we really understand what does that mean. Specifically, what we know that means is a lot of people are serving a lot of time in prison for crimes that they didn't commit, or at least that there's new evidence to establish that they may not have committed. The total number here is over 24,000 years in prison. I know in Ohio since 1989, what we're looking at is there have been 85 exonerations, and the numbers according to the National Registry is that means that they've spent a total of 890 years in prison. So what does this all mean in the simplest of terms? What it means to me as a prosecutor and as a human being is that when these wrongful convictions occur, the damage to our criminal justice system and our country is widespread. So often when you hear from innocence projects, for example, you hear the focus is on the damage that occurs to the defendant. But everybody has to pause and think about the damage that also occurs to the victim and the damage that occurs to the system as a whole. I want to speak to the damage to the victim because now in my position running a CIU, I can tell you I have had far too many conversations with victims where I've had to tell them that the 3 decades of their life where they believed the real perpetrator was not only caught, but convicted and convicted fairly is actually not the truth. And that conversation is one of the hardest conversations I've ever had, because what happens is you cause the victim to essentially live through the crime all over again. And then add to the top of that, they then have such a distrust in the system that they relied on to bring them justice. So it's difficult, and it's something that we all need to think about. And whatever motivates us to do this work, I would think if you think about the damage it does to the victim, it would make you feel much more motivated than you ever were in terms of trying to come up with solutions to the problem. Quickly, I'm going to go through the next 5 or 6 slides, just rehashing what we've learned from studying wrongful convictions in terms of how do they occur. I know John Hallway talked to you guys about this quite a bit, and a couple of things that he said is when you look at the various causes, it's so important to know that oftentimes when you study these cases, you're going to see each case often has multiple factors that led to the wrongful conviction. So in other words, when we understand that what causes wrongful convictions are official misconduct, eyewitness misidentification, false confessions, forensic evidence, perjury or false accusation, oftentimes you can have one case where you have 4 of those factors present. And that is pretty significant because it tells us so much about the failure of our criminal justice system. The next few slides are going to be just a real quick run through on the statistics of how often we see each of these factors in wrongful convictions. And one thing that I want to say, and I'll spend a few more minutes on it when I get to the issue of science, is that when we study wrongful convictions, one thing that we've been very fortunate to do is to take a real deep dive into the exonerations that occur as a result of DNA. And the reason why we've been able to take such a deep dive into those cases is because I think that that's the single category where you're not going to have much disagreement or debate about the fact that a person was indeed wrongfully convicted and they are indeed innocent. And often the reason why you don't have that debate is not only because the DNA says that they couldn't have committed the crime, but the DNA actually tells us who the real perpetrator is. So we look at those cases and we basically say they're the gold standard when we study them to try to understand how did the plane crash occur. And so what we know is in 54% of the cases, official misconduct has occurred. Then mistaken eyewitness identification, we see that happening in 28% of the cases. False confession, 12%. False or misleading forensic evidence, 25%. And perjury or false accusation in 59%. Here's what I was talking about just a minute ago, which is the DNA exonerations. And I'm giving you just a little bit, kind of a deeper dive into those cases in terms of what we've learned. And I referred to them as the gold standard. So quickly looking at this slide, what you see when we study the DNA exonerations is that 40 of the 356 pled guilty to crimes they didn't commit. That's pretty amazing. And it's pretty important right now because the conversation regarding wrongful convictions and exonerations has opened up more than ever in the last couple of years, where people are saying we ought not just be looking at trials, but we ought to be looking at pleas. Why is that a big deal? It's a big deal because so often people involved in the system have really kind of stuck to the notion that people who plead guilty must be guilty because otherwise they wouldn't plead guilty to a crime they didn't commit. Running real quickly through the rest of the stats on this slide, you see in the DNA exonerations what we see with the percentages of how often we see various factors involved. Not going to go through them one by one, but I am going to highlight the last bullet point on the slide, which is in 155 of the DNA exonerations, we have actually been able to identify the true suspect and or perpetrator. Also, it is stark when you realize that looking at these actual perpetrators, we know that they went on to be convicted of 150 additional violent crimes, including 80 sexual assaults, 35 murders, and 35 other violent crimes while the innocent person sat behind bars for the earlier offenses. Unbelievable. Oops, I went a little too fast there. Let me go back, see if I can. Hang on, my PowerPoint, my fingers are moving too quick. Well, I may not. I probably am going to leave it there instead of messing with it and trying to go back, and I'll just kind of fill you in and what I skipped over real quick. One of the slides that followed the gold standard of the DNA exonerations is really the beginning question for how do you address the problem. And this, I think, for you all, as you study what to do in Ohio, I think is probably one of the most important ways to kind of set up the question. And that is, when you think about how do you address the problem, you've got to understand the toolkit that is needed in order to address the problem adequately. And so for me, from the work that I've done in this field, when I think of the toolkit that's necessary to fix the problem, I think of various different things. I think of ethics. I think of telling prosecutors something that the United States Supreme Court hasn't really told them, which is when we think of Brady, for example, your Brady obligation really extends beyond pretrial and before you go to trial. It extends to what happens to a case afterwards. It extends to the post-conviction world. So what I'm referring here to is the ethics that the American Bar Association have put in place by saying we all ought to adopt Model Rule 3.8. So certainly I understand the Prosecutors Association in Ohio has taken the position that adopting Model Rule 3.8 is really all we need to fix the problem. But I submit to all of you guys, it's just one tool in the toolkit that you have to have in order to address the problem. In addition to understanding ethical obligations of prosecutors and what they should be doing in a post-conviction setting, it's also important to understand another tool in the toolkit is education and training. And then I know you guys are aware of this because you are looking into it, and that is what kind of rules need to be in place, what kind of rules of criminal procedure need to be in place, what kind of rules of evidence need to be in place, and also what kind of statutes do you need in order to give, whether it's prosecutors or judges, what they need to be able to look at cases, identify at a very minimum when you've got innocent people in prison, and then come up with what's necessary to try to undo that harm. The last tool in the toolkit that I think needs to be discussed is science. And Larry talked about this a little bit in his presentation. We know now more than ever, and certainly this comes from the DNA cases, but we also know from the National Academy of Sciences and the PCAST report, we know now that our criminal justice system for far too long has relied on science, or what some people would say junk science, to try to convict people of crimes. We know that's happened, and we know now, based on the advances of science, that we've got an obligation to go back and correct those. So as I said, I think the last major tool in the toolkit needs to be an understanding, awareness of past problems regarding science and how we can use science moving forward to correct the mistakes of the past. And when you think about this toolkit, I think you also have to understand that when you look at individual states in our country, each individual state is set up with different toolkits. And so you've got to gauge where people are to try to best understand what needs to be done to address the problem. And I always like to compare a few states to give you an idea of what I mean by that. And so the states that I'm going to compare for you guys now are going to be Ohio and Pennsylvania, and I actually put them in the same bucket. Although the laws are not exactly identical, I think Ohio and Pennsylvania are closer than a lot of other states in terms of how post-conviction cases are handled. And specifically, what I would say about Ohio and Pennsylvania is that it is difficult. It is difficult to address the problem because we don't have the proper tools in our toolkit legally in terms of statutes on the books and in terms of rules that have been adopted by rules committees. Next, I would say compare that with Texas. I know Texas quite well. And I think most people have this notion that Texas is so far behind in issues like this. And I think often people feel that way because, as we all know, Texas, leads the country with Florida in terms of criminal justice and the death penalty and executions. And so I think so often if people know that little fact, they often think that Texas must be far behind in terms of trying to remedy wrongful convictions. But that is not the case. Texas, and in part, it's been because of the work of the Dallas Conviction Integrity Unit, which I'll talk about a little bit later. But Texas has been very proactive in giving prosecutors and judges and defense lawyers the tools that they need in their toolkit to actually remedy wrongful convictions. I'm not here to tell you that it's easy, but I'm going to tell you that it's certainly easier to do this kind of work in Texas than it is in Ohio and Pennsylvania right now. And mostly it is because of the statutes that have been passed by the legislature. Since Dallas started producing exonerations and exonerees, every single legislative session in Texas over the last 10 to 15 years has resulted in passing laws that make it easier to identify cases where people have been wrongfully convicted and actually innocent people sit in prison. Finally, the last kind of state that I want to say belongs in its own bucket is New York. I'm sure you guys have studied New York a little bit, and the way that I define New York in terms of their toolkit and what they can do to remedy wrongful convictions is I say New York, they're kind of lucky ducks. Their laws have been written in such a way that prosecutors have great discretion in the post-conviction section, post-conviction world such that as prosecutors, let's take, for example, Mark Hale, who runs the Brooklyn County Conviction Integrity Unit. Actually, it's Kings County in Brooklyn. He actually has a tool that allows him to go in a post-conviction setting and just simply say, we are going to vacate and dismiss this case in the interest of justice. That is huge to understand. New York is not the only jurisdiction that has it, but when prosecutors have that power and that discretion in the post-conviction setting, it certainly makes it easier to do the work that needs to be done with wrongful convictions. So now talking a little bit, I want to turn to the model rule. I think Ohio is talking about passing it. They have not passed it. There have been plenty of states, however, that have adopted a variation of the model rule 3.8. And what you can do just to see what impact this has had on this work is go look at the National Registry of Exonerations and look and see whether or not conviction integrity units exist in that state and what the numbers are of exonerations and whether or not a conviction integrity unit has actually produced the exoneration. I think if you look only to having this model rule in place without having the rest of the tools, I think what you may do is you may start to ideally chip away at the culture a little bit in prosecutors' offices, but it's going to be a super, super slow process. And I don't think that you're going to remedy the problem by relying on Rule 3.8 by itself. I wanted to quickly share with you guys, in addition to the previous slide that talks about the states that have adopted a similar rule to 3.8, I wanted to highlight North Carolina and Texas. North Carolina, the reason why I'm highlighting it is because I'm going to talk to you guys in a few minutes about the North Carolina Actual Innocence Commission. They do have a variation of model rule 3.8, and Texas, on the other hand, has adopted the Michael Morton Act, which stems from the Michael Morton case that I talked to you guys about in my introduction. In Texas, what they did as a result of Michael Morton's exoneration and the real perpetrator's convictions, they actually got the legislature to pass the most sweeping discovery reform that had been passed in 50 years in that state. And in a nutshell, what they did is they said you have to have an open file discovery policy. And of course, it's not really a policy when it's mandated by statute. But on top of that, what they did is they codified the prosecutor's ethical obligation to disclose exculpatory, impeaching, and mitigating information. And what's critical here on this slide is to understand they codified it in two important respects. One is they said, you've got this obligation at any time before, during, or after trial. And the statute also says that this obligation in a pretrial setting exists with absolutely no reference to a materiality analysis, which is hugely important when we're talking about a prospective prosecutor's obligation to turn over Brady information. So that's kind of where we are in terms of the ethics and model rule 3.8. Just real quickly, and you guys will have this PowerPoint to look at later, I also suggest that you guys look at the ABA standards for prosecutorial function. And specifically what I've put up there are what should we be doing in post-trial motions? What should we do with our duty to defend conviction, and understanding that it's not absolute? And then finally, look at the responses to new or newly discovered evidence or law, which is 3.8.3. I'm going to move quickly because if I don't move quicker, I'm going to probably run out of time. I also said to you that one of the tools in the toolkit that you really need to address this problem is the education and training. And on the slide in front of you is an example of something Texas did. And once again, I got to say, Texas did it because they paid attention to what happened in Michael Morton's case. And specifically, Texas actually passed a law that mandates Brady training for every prosecutor who prosecutes any case that is other than a finable only offense. In other words, if there is any kind of prosecution that could result in incarceration, any prosecutor in charge of that has got to do a yearly mandatory Brady training. That speaks volumes in terms of understanding how important it is for prosecutors to be taught about what their ethical obligations are and what their constitutional obligations are. at the outset, when Texas started doing this for a few years ago, they really had a rough time because prosecutors really have not been trained properly about Brady. What we've learned in conviction integrity work is that oftentimes having a defense attorney be part of the training is helpful because defense attorneys look at Brady through a different lens. And I think Texas over the last few years has understood that and is getting better in terms of how they provide the training that's mandatory for all prosecutors in the state. So I also said a very important tool in the toolkit is understanding how you utilize rules and statutes to accomplish what you need to do to remedy the mistakes of the past, but also put protections in place so we're not doomed to repeat them. And I also mentioned that one of the important kind of subsets of this tool is discovery. And I understand discovery has been a hot topic in Ohio and that there were some changes made recently in regard to discovery. But that discovery in a post-conviction setting, as I understood it, and I think it's Rule 16, is really only dealing with discovery in a post-conviction setting in death penalty cases. I think that clearly, if we really want to tackle this problem, we need to make sure that discovery is something that all people in a post-conviction setting are able to get with certain limitations. Another particularly ripe area for being able to right the wrongs of the past is what your rule or law says in regard to motions for new trial. I know recently in Maryland, they actually passed a statute, and I think this was largely done as a result of efforts put in by prosecutors and prosecutors where there are conviction integrity units, but they wanted to make it very clear that you should have a tool available to you that when you've identified a miscarriage of justice, and even if that's 20 years later, you ought to be able to get back into the courtroom and do something about it. And so it's essentially like an out-of-time motion for new trial, so you don't have to worry about jurisdictional problems and time bars. And I understand that you guys in Ohio have a pretty robust rule regarding this too, and I think that's Rule 33. Always helpful to look to see what else can be done such that you've got what you need to get back into court. And most of you guys have probably heard about or at least familiar with the case out of Missouri where the Conviction Integrity Unit went in and tried to actually file something saying that they had identified an innocent person. And unfortunately, the Conviction Integrity Unit was thwarted, and the judge called in the Attorney General's office, and there were real questions about whether or not the Conviction Integrity Unit had the tool of being able to open up the case and go back in court and right the wrong. Also tell you, you've got to look very closely at your post-conviction statutes. And I hearken back to Felix Frankfurter's statement in regard to this. It is a shame if we get so caught up in finality of convictions that we cannot identify and set free the people that have been convicted who are innocent of the crimes. And in Texas, I will say, they've got a post-conviction statute that doesn't make it jurisdictional. And procedural bars are things that can be waived. And I submit that that actually is a great model, kind of separate from New York's statutes that allow prosecutors to go in and just do it based on the interest of justice. So what I'm saying here is I think you need to think long and hard about statutes that make it possible to open up the door and get a judge to look at a case. And you need to look at statutes and say, okay, well, maybe if we're still going to say we don't want to open the door wide open, we ought to allow prosecutors to actually not assert procedural bars. They ought to be able to say that their oath to do justice says that there are some times that procedural bars are not doing justice. There's a few other states that also have statutes regarding just actual innocence writs, and those are pretty helpful as well. Another area that I wanted to talk about is statutes on the books that have been passed regarding how to deal with the science issue that I've kind of set up. And that is, how do we go back and remedy cases where junk science has led to wrongful convictions? An example on the tip of my tongue is the shaken baby syndrome cases, and we don't refer to it as shaken baby syndrome anymore, and the bite mark cases. I once again use Texas to illustrate how you can actually pass a statute that allows courts to get back into a case based on changes in science such that we can remedy past convictions. And in particular, what I'm referring to is in Texas in the Code of Criminal Procedure, it's Article 11.073. If you want to look at what I think is a really good statute that allows judges to use new science as a grounds for getting back into court and granting relief. I also want to take a minute to talk to you guys just real quickly about right to post-conviction counsel. And of course, part and parcel of this is so many of the problems that we have studied and seen throughout the country is too often in a post-conviction setting, there's not enough training and education. You don't have enough defense lawyers who are qualified to do the work. And then sometimes you have a situation where you have a state where there is no right to post-conviction counsel anyways. And so a lot of the litigation is being done pro se. Texas, once again, dealt with this because they had dealt with so many exonerations such that they passed Article 11.074 of the Code of Criminal Procedure, which is actually a provision that says that a judge can indeed appoint counsel in cases where there is an issue about whether or not the individual is innocent or whether or not the individual was convicted based on a statute that's been declared unconstitutional or some other problem that leads one to believe that the case involves a wrongful conviction. And finally, the last bullet point on this slide is just the dismissal in the interest of justice, which is what I talked about in terms of New York's toolkit and how prosecutors in New York can go in and actually get a vacatur or a reversal just saying it is in the interest of justice. And Mark Hale in Brooklyn often says what Larry said in his presentation, which is that is about us looking at cases now through the lens of what we know, and we know it's so different than the way we looked at them decades ago, and we simply say, we cannot say this conviction has integrity. And if we cannot say the conviction has integrity, then Mark Hale will go in there and say it should be dismissed in the interest of justice. So that's all about how do we address the problem. And now I'm focusing just a little bit on how do we address the problem in regard to using science. I'm not going to go through everything on here, but I'm hoping that you guys are all familiar with what I referred to a little while ago, which is the National Academy of Sciences report from 2009 and the PCAST report that came through in 2016. Fascinating but dense reads, but also important in trying to understand how have we gotten it wrong in the past, and then how can we use science moving forward to do better? Just real quickly, this slide really highlights the cases that those two reports are telling us we need to look long and close at, and that is we've had problems with fingerprints, bite marks, hair comparison, fiber comparison, and believe it or not, shoe prints. So moving along, now I'm going to try to talk briefly about the question of who should address the problem and where. And historically, what we know since we've started really recognizing wrongful convictions and exonerations in our country, historically, when we were asking ourselves, well, who should deal with it outside defense lawyers, outside the Innocence Projects? And of course, by saying outside those two entities, there's a recognition that just saying it's a defense attorney's job to fix the problems is kind of foolhardy. We cannot do it if we just leave it into the hands of Innocence Project and defense attorneys. Although they do a good job, they just don't have enough of the resources that's needed to fix the problem. So when we started asking that question, who else then? One thing that we heard over and over again, and I was a part of this conversation, was, well, you know, I'm not sure we can say who it is, but I think we can say who it should not be. And specifically in the early conversations, that answer was it should not be prosecutors. And too often people said it shouldn't be prosecutors because that's akin to the fox guarding the hen house. That's akin to the fox guarding the hen house. And I'll tell you, there's still quite a few people that feel that way. But because that question was raised early on, I think we got the North Carolina Innocence Inquiry Commission. And you guys, I think, have studied this a little bit, and I'm going to give you a couple of my thoughts on the North Carolina model. early on when the North Carolina model was adopted, and of course you guys know the legislature actually enacted a statute that created the commission, and they actually enacted rules in regard to how they work and what kind of cases they can look at, and that was back in 2006, 2007. So many people thought the rest of the country would go that way. They thought that having an independent board who neutrally looked at factual assessments to determine if somebody was innocent was going to be the answer to addressing the problem. And North Carolina, as I said, has actually done a good job. I want to share with you guys some of the statistics regarding North Carolina. Specifically, since the North Carolina Commission was set up in 2007, there have been 2,881 claims presented to the commission. They have actually closed 2,828. They've had 17 hearings, and they've had 12 exonerations. That's significant, but when you look at all the numbers nationwide, and you understand that they've been in existence since 2007, and then you start comparing it to what conviction integrity units have done, I think you will see, when I talk about conviction integrity units a little bit more, that maybe this model is not the solution. And it's interesting because everybody thought it would be, but as of today, almost 15 years after it was first thought of and then enacted, there's not another single state in the country that's gone the way of the North Carolina Innocence Inquiry Commission. I also want to point out to you guys, kind of separate from looking at the numbers of what they produced, they also are very narrow. Do you remember John Hallway was talking to you all about what kind of funnel do you have? What kind of funnel do you create in terms of the types of cases that you look at? And he generally will say the wider the funnel, the better. The more narrow it is, the less people you're actually going to be able to identify and set free that are innocent in prison. And the North Carolina model by statute is incredibly narrow. The only thing that they are tasked with the ability to look at are actual innocence cases. They cannot look at any other kind of procedural infirmities with the actual case. They can only do the actual innocence. They cannot look at sentencing inequities. They can only do the actual innocence. And one thing they also require by statute is that when they get to looking at these cases that are submitted, they're only going to look at cases where there's been a complete waiver done by the defendant themselves. That's a big conversation that's taking place with conviction integrity units all over the country right now, which is, should we be requiring a full waiver of all privilege of anybody who's claiming innocent just to get somebody to look closely at their innocence case? So there's issues with the North Carolina Innocence Inquiry Commission, although they've done good work, but there's no doubt that there's real issues with that model. Other than that model, I think that this has also been discussed with you all on your task force, is the attorney generals, and Larry brought this up when he spoke. So far, what we've seen as an answer of who should address the problem and where, we've seen in 3 different places, we've seen states say maybe who it is the attorney general, not individual prosecutor's office, and it should be housed in the attorney general's office. So we've seen that in Michigan, we've seen it in Pennsylvania, and we've seen it in New Jersey. I will tell you, all 3 of these are so recent that for me, the jury's out on whether or not they're going to be effective. I can tell you that what I know of them now causes me concern about how effective they can be. And in particular, I'll refer to the one in Pennsylvania. Larry mentioned that this one was formed not too long ago after our unit started having success, and the Attorney General in Pennsylvania, I think, recognized that conviction integrity units are necessary. So he actually created one, and he created one, I think, maybe without really understanding how difficult it was going to be for the Attorney General to actually get cases to look at, to not only identify the problematic ones, but figure out how to remedy them. And what I mean by that is the Attorney General doesn't have the jurisdiction to where he can just automatically pick which cases he wants to look at. Instead, what he has to do is he has to rely on elected officials in all the other counties in Pennsylvania to actually agree to send a case to the Attorney General's office so they could do a real conviction integrity review. So as I said, there's some problems, I think, with it, but really the jury's out in terms of how effective these are going to be as a model to identifying and remedying wrongful convictions. Lastly, before I get into conviction integrity units, I just want to talk real briefly about what Connecticut's doing. And I'm assuming you guys have had some conversations with folks in Connecticut because they have been studying the issue as well. And just recently, I heard from one of the prosecutor in the state's attorney's office who told me that their task force just recently completed its work. They've made recommendations and they have been sent to the chief state's attorney. At this point, as you can see on the slide, the way Connecticut's going to do it is they're going to start off with a staff of 2 prosecutors, 2 inspectors, a paralegal, and a secretary. And they think at this point that they can operate with that kind of staff and do conviction integrity work with no need for legislation, but they understand that they're going to have to get legislation passed in order to keep the funding going to do it. So as you can see on the last bullet point, the task force is now in the process of attempting to secure the backing for that type of legislation, and they're talking to the governor's office about how to do it. Connecticut is set up so differently than most other states in terms of how they prosecute cases, because I think you guys probably know they're not elected prosecutors, but they're appointed. So it's going to be fascinating to kind of watch how this rolls out and how it works. Too soon to say, given the fact that the task force just made the recommendations and they're just starting to move on it. So CIUs, so as I said, in the beginning, people were skeptical. They thought it was the fox guarding the hen house. And really, I heard many people for several years say that CIUs were going to be a flash in the pan. Either one, because they could not look at their own cases and root out the cases that were bad, or 2, believe it or not, there were people that thought that the only time CIUs could be effective is if they were looking at cases where there was DNA. And because there was a belief that we would run out of the old cases where there was DNA, folks actually thought that CIUs would no longer be needed. Of course, we've learned that that is really nonsense. We've learned by studying exonerations that many of the exonerations are occurring now without DNA. And it's forcing us to look very closely at all the other causes and make us try to figure out when we have unreliable evidence versus reliable, such that we could actually vacate bad convictions. When you look at this graph in terms of what's happened with CIUs, I think you'd probably agree with me that what we've seen is, instead of these units becoming extinct, we instead have seen an explosion of the units. And I say it's an explosion because if you look at probably from 2015 to the present, we've gone from very few to where now we have almost 75. So in my opinion and in my experience, I really think CIUs are the answer. And I think that where we're going to get to is CIUs are not going to be this kind of, anomaly. Instead, it's going to become an important, necessary part of any prosecutor's office. Much like when you look at a police department, we now understand that an internal affairs division or department is a necessary part of a police department. If you are trying to figure out, do you have a state commission? Do you have an AG's office that handles it? Or do you have a CIU? I think when you're studying that question, you've got to say, well, what should they be addressing? And this goes back to John Hallway's, what is your funnel going to be? And probably more people, at least in the CIU field, have a very narrow funnel. Most CIUs to this day are saying the only cases, very much like the North Carolina Innocence Commission, are only going to look at credible claims of actual innocence. Other units like ours here in Philadelphia, we say, wait a minute, we don't want such a narrow funnel. We're prosecutors. Why do we have to have such a narrow funnel? If we take an oath to do justice, should we not be looking at more? And so specifically what Larry said when he kind of recreated the unit in our office, he said, our funnel is going to be wide enough to not only look at actual innocence, but we're going to look at wrongful convictions, and we're also going to look at sentencing inequities. So that really is a question, I think, that has to be addressed in trying to figure out how do you solve the problem. Another question that you don't hear that often, but if you do a comparison about how CIUs in different states work, is when do you address the problem? And this is a question that's addressed in various policies and protocols of CIU units. And that is, when does a CIU actually have, for lack of a better word, jurisdiction internally over a case in their office such that they can do something about it? Some units have policies that say they can look at a particular case immediately after a person gets convicted, regardless of whether or not there's a direct appeal pending. And other units say, no, the only time the CIU is going to be able to look at a case is after all direct appeals have been exhausted. And so I think that is a question. And oftentimes I will tell you the answer to that question is going to be driven by the rules and the statutes that exist in the state of jurisdiction, because it just depends on your toolkit and what the CIU is going to be able to do. In states where post-conviction claims or petitions are jurisdictional, often what that means is for a conviction integrity unit to be able to do real work, they're going to have to get involved sooner. They can't wait until everything's done, because if they wait until everything's done, they may never be able to get back into the door, particularly because jurisdiction can't be waived, even if a prosecutor thinks there's a problem with the case. How am I doing on time, Judge? Can I have about 10 more minutes and then opening up to questions?
Yes.
Great.
Yes, 11:30. Go ahead.
Thank you. So the last part of this presentation before we open up to questions is I wanted to talk to you guys just a little bit about lessons that I think we've learned in the broader field of conviction integrity work, but also in my personal experiences having worked in Dallas and in Philadelphia. So starting with Dallas, I wanted to give you guys just a little historical perspective about how that unit came about, and quite frankly, how that unit has been so successful. What happened in Texas is back in 2001, the Texas legislature passed its first post-conviction DNA statute. And that was pretty significant because in Texas, I think most people felt like that was going to be the tool necessary for innocent people to be able to say, hey, I'm innocent, I've been wrongfully convicted, let me out. The statute was well written, and it was not written in a narrow way. But despite that fact, most prosecutors throughout the state fought it. And every time a request for DNA testing was filed, prosecutors did what they could to legally oppose it. And unfortunately, they were successful more often than not. And in Dallas, they were particularly successful. In fact, what Dallas did in the DA's office is they opposed almost every single request. And those DNA requests and the denial of it was often appealed to higher courts. What Dallas experienced is when the appeal was successful in the defendant's favor, then the DNA testing happened. And in many cases, that proved that the defendant was in fact innocent. And so when a new DA was elected, after that statute had gone into effect, and after there had been at least 5 or 6 years of opposing testing despite that statute, the new DA said, this is crazy. Isn't a prosecutor's job to try to do justice? And doing justice, as Larry said, is not being afraid of the truth and wanting accurate results. He said, isn't that what we're supposed to do? And if DNA can prove when somebody's guilty, then certainly it can prove when they're innocent. So he started brainstorming, and he came up with the idea of the Conviction Integrity Unit. And what he did is he got funding from the Commissioner's Court in Dallas to actually hire a few people. And their mission at the time was really quite narrow. Their mission was to actually go back and look at all the cases where that same office had opposed DNA testing, and the defendant was not successful on appeal, so they never got their testing. So they said, we're going to go back and we're going to look at it all, and we're just going to start doing the testing. And so what you see on the slide in front of you is the team that did that. And they started doing all this testing. And of course, they were not only blessed with that attitude, they were blessed with the fact that the lab in Dallas had maintained most biological evidence that had ever been collected for decades. So they had the ability to say, yeah, we're going to do the testing and let's get the testing done. And much to everybody's surprise, I think throughout the country, at least those people that were paying attention, they had tremendous success. They started seeing lots of exonerations coming out of a unit in a prosecutor's office. The elected DA who started that unit had 2 terms. And then what happened in Dallas is a new DA was elected, as you can see from this slide. Susan Hawk actually beat Craig Watkins in a very heated race. I put this up there because it was really fascinating to kind of witness what was going on, because at the time, Craig Watkins was a Democrat, and his notion was really kind of foreign for prosecutors to do this kind of work. By the time Susan Hawk ran against Craig Watkins, Susan was a Republican, and much to a lot of people's surprise, part of her platform was, I'm going to have a robust conviction integrity unit. I am not going to get rid of it. And this was really the birth, I think, of the politics of prosecutors understanding that conviction integrity work is not really partisan. You know, once you give an idea to your community of how a prosecutor can play this kind of role and get results, I think the community demands that that work be done. And Susan saw that. And Susan said, I'm going to be committed to it. And that's, in fact, how I actually came to work in Dallas running that conviction integrity unit. Interestingly, Susan Hawk made a big mistake. She got elected, she had that platform, but when she took over, she didn't really understand kind of what we all understand now as best practices of how to run a conviction integrity unit. And so what she did is she kind of scaled back or set the clock back on some of what Craig Watkins had done, because Craig Watkins had said, not only am I having a unit, but the unit reports directly to me. And the unit, as far as being on an organizational chart, goes above the appellate post-conviction unit, because he understood that the work of a conviction integrity unit was going to cause a whole lot of friction with the traditional ideals of appellate prosecutors. Because keep in mind, appellate prosecutors, their job is to defend convictions. And in Dallas, they are the ones that had opposed the DNA testing. So Craig understood that. And so he made sure that he kind of cut that conflict off in the office by making sure that the CIU organizationally was over the appellate and post-conviction section. Now, Susan Hawk didn't understand that, so she changed it and actually put the CIU on an equal level of the appellate post-conviction section. And what that meant was, for a couple of years when Susan Hawk was DA, there was internal fighting that went on a daily basis, because you had the appellate post-conviction prosecutor saying, fight, 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 defend the conviction, and you had the CIU saying it is not a defendable conviction. And then there was a question of, what do you do when you have that kind of internal fight? What happened in Dallas was, for a period of time, exoneration slowed down because it was not efficient for the unit to be caught up in that fighting on a daily basis. And the Innocence Project in Texas and the exonerees, who were very politically powerful, took note of that fight and the slowdown in the work. And the president, actually, of the Innocence Project's board said, you know, I've got to try to convince people that you've got to have, not only have a CIU, but they've got to be independent and they've got to be distinct from the appellate post-conviction prosecutors. So he said, the way that I'm going to do it is I'm going to demonstrate how that kind of internal conflict slows down a CIU. So he started writing on all of the DNA exonerations, and he was able to establish that folks that had been exonerated as being innocent based on DNA had spent years of extra incarceration because the appellate post-conviction prosecutors had been fighting, saying, we're going to defend the conviction, rather than looking at the case through the lens of, oh my gosh, we might have convicted an innocent person. And so what you see on this slide and the next few slides are some of the examples of his work where he looked at these individual exonerees and he was actually able to establish how much extra time they did because of that kind of fighting. So it was the one that I just showed you, Billy Smith and Patrick Waller. And then this person actually looked at all the cases, and look at the numbers there. It's quite amazing. So Dallas at the time when he was doing this work had 26 DNA exonerees. 17 of those people had applied for DNA testing between the fighting years, is what I call it, when no DNA testing was getting done between 2001 and 2006. And what we see is of those 17, prosecutors opposed testing in 13 of the cases. And every single one of them spent more time in prison as a result of it. So that's kind of what we saw going on in Dallas. Lots of really good things, but then a setback. And then what happens is a new DA gets elected once again on the platform of CIUs are important, but this time the platform is, and it's important to let them be independent, and it's important to understand the different role they play from the appellate post-conviction prosecutors. So at the end of the day, when we look at the statistics from Dallas, we see really great success. We've seen 59 exonerations since 2001. Most of them are DNA, 32 more than any other jurisdiction in the country, although there have been 27 that are non-DNA. So turning real quickly now to talk just a little bit about Philadelphia, the backdrop to having any conversation about what's been happening in Philadelphia requires an understanding of what I think and what Larry thinks is one of the biggest problems we have in Philadelphia in mass incarceration, and that is how many people we have serving life without parole sentences. This has affected my life on a daily basis because what it's meant with these high numbers is that we have just been overwhelmed with people writing to us on a pro se basis saying, look at my case. Either A, I'm innocent, or B, there is something wrong with my case such that it resulted in a wrongful conviction. Larry talked to you guys a little bit about where we were in Philadelphia as far as the conviction review unit before he came on board. And quite frankly, the best way to sum up what Larry said and what my next couple of slides say is that what Philadelphia had before Larry got elected was Philadelphia had a crino. I'm not sure if John Hallway referred to that when he spoke to you guys, but basically the crino is when it's a conviction review in name only. So that's what Philadelphia had. And I think there's no case that really exemplifies that more than the case of Anthony Wright. And I don't know if any of you guys are familiar with Anthony's case, but Anthony's case is an amazing case to study. A great piece in the Rolling Stone was written about Anthony Wright. But in a nutshell, Anthony Wright had been convicted, maintained his innocence despite a supposed confession that he claimed was false. And after many, 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 many years of trying to prove his innocence, DNA testing was done. And most people would say it proved he was innocent. Unfortunately for Anthony Wright, it didn't get him an exoneration. Instead, it got him the right to a new trial. And this office elected to retry him, even though the DNA, in my opinion, exonerated him. They retried him, and the jury quickly, after that trial took place, quickly, in 45 minutes, acquitted Anthony Wright in the second trial. And Anthony has just become really the poster child of Philadelphia going from a crino to a real conviction integrity unit. Ultimately, because Pennsylvania does not have a compensation statute, Anthony Wright had to sue to seek relief based on a Section 1983 cause of action. And the city of Philadelphia ended up settling for $10 million. So, you know, Larry comes on board, he resets it, He says, I'm going to do better. And I feel very grateful because every promise that Larry made, he's kept in regard to the unit. He's given me the people. He's given me the resources. He's given me the independence. All of the best practices that we've learned about conviction integrity units are things that Larry, I think, cherishes and lives up to. So in Philadelphia, here's our numbers. Since 2001, according to the National Registry of Exonerations, there's been 39, significantly less than Dallas. Only 2 of them have involved DNA and 37 have been non-DNA. Super important for you guys to understand that when you study this issue, every jurisdiction could be different because so much of it is driven by how the law enforcement agencies investigate crimes. So I highlight here the difference between what I said happened in Dallas with Philadelphia. Dallas, law enforcement investigated crimes and collected evidence that contained biological material such that it could be tested, such that you could have DNA exonerations. Philadelphia has not done the same thing. Oftentimes they didn't collect evidence. They relied on eyewitness identifications and confessions or statements from witnesses. And even when they did collect evidence, oftentimes it wasn't stored and kept in such a way that it was really good material for DNA testing. I'm going to wrap up with the last couple of minutes with just a few thoughts. This is a photo of John Thompson. You guys are, I'm sure, familiar with the Connick case out of Louisiana. And that is such an important case because it talks about how prosecutors have immunity. And it was a case involving really significant Brady violations. Before he died, he was interviewed and he talked about the world as it should be in the context of fairness, procedural justice, and justice in our criminal justice system. And specifically what he said is the world as it should be is where the legal system prevents misconduct and ensures timely defense access to exculpatory evidence, gives a path to relief to those whose convictions were tainted by misconduct, and holds prosecutors and their employers accountable for serious misconduct. So I say that to set the stage for some of my last thoughts about conviction integrity units. I've mentioned it multiple times. Larry mentioned it. If you go the way of a conviction integrity unit, the unit has got to be independent. This speaks to setting up a world where it's not really the fox guarding the hen house, but understand in setting up the independence that when you put people in a prosecutor's office that are going to do this work, it is going to be like having an internal affairs in a prosecutor's office. And the people you put in those positions are often not going to be very popular. We've had lots of battles in our office, and most people would say our office is one of the more progressive ones in the country. But when you commit to do conviction integrity work, you're committing to changing the culture. The experts, y'all heard from John Hallway, but Barry Scheck is an expert too. And what I highlight when I refer to these two is John spends a lot of time on Sentinel reviews, and he spends a lot of time saying that the way we identify and solve errors in the criminal justice system is to try to do it in a way that we don't blame. And certainly that's appropriate in some circumstances. Barry Scheck, on the other hand, often says, how can we say that we don't blame people if people have been the cause of the wrongful conviction? And in particular, what Barry talks about is that when you have prosecutors that are committing Brady violations, and not just your standard negligent failure to turn over, but they're committing Brady violations either intentionally, knowingly, or recklessly, he says there are times when there has to be blame. And in reality, I think Hallway and Barry are both right. You got a little bit of both when you study the causes of wrongful conviction. I am going to jump to the end because I think we're nearing the time that we want to shift over to questions. A lot of, when you look at this PowerPoint, if you look at it, you're going to see a lot of quotes from materials from Hallway and Scheck talking about how do you set it up in the office to make sure that the conviction integrity unit is a real unit and not a crino. So I end with these thoughts. Keep in mind that exonerations are certainly important when you're trying to figure out whether or not you've got a real unit or a crino. And look at what Brooklyn has done in New York. They exonerated a whole lot of people in a short period of time. Then look at what we've been able to do in Philadelphia. As Larry said, we've had 15 exonerations since 2018. But keep in mind, and I refer a little bit to Ohio. We talked about what the numbers in Ohio are, which is 85 exonerations. And what we know of those 85, 6 of them have involved the CRUs, and I understand there's 2 of them now. But understand, exonerations cannot be the only measure of success. Finally, if you go the CIU route, the CIU has got to have support from the top. And I'm talking about Larry or any other elected DA. And then, as some of you guys have heard me say before, it very much is like an internal affairs. That's the only way I think you can make it work. And you got to understand that the CIU, at least initially, is not going to be real popular in a prosecutor's office, because prosecutors generally don't like to say or admit when they've made mistakes. So that is it for me.
Thank you very much, Patricia. That's okay. We're back up. We did have some, excuse me, written questions that are in the chat column. That oh, Steve, I see you're still here. You want to ask you had the first question. If you want to ask it, go ahead. We still have Larry. Thank you, and Patricia. You're mute, Steve.
Okay. But my question was to DA Krasner, which is when it's the most appropriate time to approach the court regarding an exoneration, because you had mentioned that early on some of the judges were resistant, and obviously you don't want to approach the court too soon, where the court is less inclined to at least be amenable to doing something. So at what point in time does your unit say, okay, we have enough now, let's approach the court?
Thank you for that question. Let me make sure that I explain myself well. I'm not sure I did. And then I would actually ask Patricia to answer the question of procedurally, or at what point in the cycle of a case it is best to approach the court, which also may be somewhat of a local consideration. What I was trying to explain is that when our administration came in and we were doing a number of things that were not the usual practice and culture of the Philadelphia District Attorney's Office, there was a hesitancy on the part of members of the judiciary. And by the way, my wife was a judge for almost 20 years in Philadelphia County, including at the time when I first became DA. So I have tremendous respect for our judiciary here, and I know a lot of them very well. What I was explaining is they were so accustomed to the position of the DA's office being that they were always opposed to everything the defense wanted. They were somewhat suspicious when we were in agreement with the defense on almost anything. And I think during the first, second, third, fourth exoneration, some of them were very hesitant at first and distrusting. But as they closely examined the reasons behind these different exonerations, and as they saw a pattern emerging over time where we were not trying to exonerate everybody. In fact, the number we were trying to exonerate was a relatively small percent, and our reasons were solid and carefully rendered. The research and the law was correct. I think as that came forward, and as they saw the press response, which was, I mean, I'm just being realistic about this, which was generally very favorable, surprisingly favorable in a way that I would not have expected 10 years ago, including from people with a much more conservative perspective, they became more comfortable, they became more trusting of us. And then I would say over the process of about a year and a half, with a few exceptions, they have been very willing to listen to our position. But in terms of the life cycle of a case, let me defer to Patricia.
So the short answer is, Larry is right. I mean, it's really kind of a local issue, and it actually can boil down to an individual judge issue. And I will say, I think our unit is pretty unique in the sense that when we handle a case, we do it both in state court and in federal court. And so we are always mindful of, the laws that apply, and we're very mindful of the individual judges that we're dealing with. Because, however, we knew when we started doing the work, there was such a skepticism about it. We knew that there was never going to be an occasion, and I'm not so sure that it would be good even if we could, but there was never going to be an occasion where we were just going to walk in and say, Judge, let this person out because we think they should get out. We knew that. And so, as Larry said, what we do in every single one of our cases is we do a very, very thorough investigation, and then we do thorough briefings such that we can lay out what happened, what new evidence we have, and why we think legally the person is entitled to relief. And I'm going to close the answer to this question with saying one thing that I neglected to say, and this kind of goes to what Larry said. One thing that is really different about this kind of work, and that we all need to make sure that we try to educate about, particularly with judges, is that for conviction integrity work to really be successful, it needs to be collaborative, not adversarial. It needs to be where we're all saying it is in everybody's interest to identify the innocent, at a minimum, identify the innocent and get them out. And so we should all work together. And that is so foreign, I think, to a lot of judges, because that's just not the way the criminal justice system has worked. And so as we try to get the judge on board with what our recommendation is, we try to get them to understand it's not we're prosecutors behaving as defense lawyers. We're just collaborating with them to do what Larry said, which is get accurate results and uphold our oath to do justice.
Patricia, two real quick follow-up questions on that. What is the mechanism that gets you before that trial judge? Has there been a motion for a new trial filed? Are you coming in filing some post-conviction stipulation? How are you technically doing it in Philadelphia?
That's a great question. And this is where, when I was talking about the toolkits and understanding how states are different, the laws in Pennsylvania, in my opinion, are pretty draconian. They're not very favorable to this work. So we do not, as prosecutors, have the ability to file something and go in. There has to be a petition, whether it be in Pennsylvania in state court, it's a Post-Conviction Relief Act petition that the defense files. The court has to have jurisdiction over it. We can't waive jurisdiction. So we really have to have the goods to get in. And as crazy as this sounds, I think most people would know that in federal court, AEDPA and federal writs of habeas corpus have just been seen as so narrow and hard to get anywhere with. But Pennsylvania law, in my opinion, as I said, is so draconian. Sometimes we actually find ourselves in a better forum in federal court to do this work, because in federal court, as prosecutors, we're able to waive the procedural bars. And so we can get into court sometimes in federal court where we may not have been able to do anything in state court.
The other follow-up question, thank you for that answer. The other follow-up question, have you had an occasion where a case is so recent that you're investigating that the normal appeal process itself has not concluded, and the extent to which, as a consequence of that, you're then dealing with perhaps an appellate district and asking, I don't know if you have a mechanism seeking their stay. Is there some procedure there, or again, is the law deficient on what you can do in that setting if your investigation reveals what you believe is a wrongful conviction, actual innocence, and yet the actual appeal hasn't concluded as yet? How do you deal with those cases? Or maybe you haven't.
And so we do get them. And I'll tell you, kind of at the outset, the big problem we deal with is we have what I call a super long queue. We've got about 1,500 cases in our queue to review right now. And so we have to triage them to figure out which ones are we going to look at first. And so oftentimes what you see is you probably are going to look at the case where somebody's been in for 40 years before the case where somebody just got convicted last month. However, let's say we are looking at a case, because there are sometimes when we look at those cases quicker, say, for example, like Larry talked about Chicago having the bad detectives and false convictions Sometimes you look at a class of cases. And so we've got a former homicide detective who is sitting in jail awaiting prosecution and trial on terrible crimes. And unfortunately, those crimes played a role in his homicide investigations. So we're looking at all of his cases. Some of those cases have been cases that were just recently tried that are still on direct appeal. And so what we have been able to do in those cases, fortunately, is get the Superior Court, our intermediate appellate court, to actually remand the case back to the trial court such that a record can be built to have an ability to say it's a wrongful conviction. And I stress that because I think all of you guys know, typically on your direct appeal, you're not going to be able to do this because the record's not going to have the information you need to identify the case as a person who's innocent or a wrongful conviction. So you've got to figure out, how do you get the record built? And if there's a way to do that, then there's a way, I think, to get those cases handled.
Thank you very much. So Judge McIntosh, you have the next question as well. I'm just going through the chat line. So if you want to.
Okay. Yeah, just real quick. This is just sort of best practices. I think you indicated that only about 4% of the requests that are made to your office do you actually accept. So in terms of your best practices, what are one or two things that tend to come up routinely where you accept cases, or the one or two things that tend to come up routinely where you immediately know or understand, okay, this is something that we probably cannot accept?
So let me say it's really difficult because I got to say, we're not, as I said this, we're not in the business of defending convictions. We're in the business of exercising our discretion to identify the cases where the conviction doesn't have integrity. So you got to kind of get your mind wrapped around that notion. And so how do you do that? And once again, I use the phrase, you got to triage the cases. You got to look at them and you got to say which ones look like a case where there's some red flags that say I should devote our limited resources to these cases instead of these over here. And what we've seen so far is there are patterns. Unfortunately, Philadelphia, I think, has a bad history of false confessions. We know that, as I said a minute ago, there's some detectives that routinely engaged in behavior that led to either false confessions of suspects or unreliable statements from witnesses. So there's red flags there. There's red flags with eyewitness identification. Philadelphia's had problems with those quite a bit. And then probably most importantly, what we see more than anything else is we see Brady violations. And oftentimes when there's the Brady violation, that's not terrible to kind of flesh out because it's a matter of opening up the file. And I hate to say this, but sometimes when we open up a file and look at it, it may be the first time a prosecutor in this office has opened up a file and looked and found, like Chester Holman, Larry talked about that case. We looked at it. It was all there screaming at us saying, my God, you got the wrong person. So those kind of, we know what we're looking for. That's not to say that it's always going to be that. So we always have our kind of mind in tune with the idea that there could be other issues, but you do get a sense of the red flags.
Very good. Thank you. So the next person was Judge Rocky Koss, who had to leave for another meeting. So, and he's making a suggestion, which Justin, I hope you'll see, we'll print these out and we'll take it up at our next meeting. Doug DeMolt of the Attorney General's office, you're next up. If you still want to ask the question. It's a good question.
Thanks, Ms. Cummings. One of the questions I had was about the policy reasons behind not to allow or not to allow or require, I should say, a waiver of privilege by people asserting a claim. I understand the policy reasons if it for doing that. If it's a procedural kind of defect in the proceedings, there could be good reasons not to require a waiver. But with respect to an actual innocence claim, what would be the downside of having that kind of waiver required if this is a truth-seeking function?
So I'm going to try to jump into that question and split it into two answers because I think you kind of posed it that way. So just focusing on the actual innocence part, I got to be real honest with you. A part of my thinking is influenced by the fact that I was a criminal defense lawyer for many, many years. And I understand that sometimes defendants maybe say things that don't necessarily mean they're guilty, but it's stuff that you wouldn't necessarily want somebody to know about, because people may not understand it and they may interpret it as such that, okay, this means your client is not innocent. So my position is, I don't really see the benefit of requiring a complete waiver up front to look at a case. The way we do it is we kind of do an in-between. We do a limited waiver, and we understand that with actual innocence claims, that sometimes that limited waiver has to exist. For example, a lot of times we want to talk to the defendant ourselves. We want to actually go interview them. And so a limited waiver is necessary for that. Another time where you need some sort of waiver is if you're looking at a Brady case, like I just said, we do a lot of. I need to know, did the defense trial counsel get that information? You know, it's not enough for me to just say I'm seeing it and it doesn't look like it was used or disclosed, but I need to find out, can I look at trial counsel's file? So there's certainly reasons to have some sort of limited waiver. I just have not seen anything that persuades me that a full waiver is necessary to really start taking a look. And I will say the second part of your question was, you said you kind of understand it when it's not an actual innocence claim, but wrongful conviction. One thing that I have also learned is sometimes what happens is you start looking at a case as actual innocence, because that's how the claim comes to you. And you realize after a lot of work and an investigation, you may never get to the point of having enough new evidence to make you feel confident, whether it's clear and convincing or probable cause. You may never get to say, gosh, I think I can say he's innocent. In fact, I'm not sure. But instead, what you find is you find there are other problems with the conviction such that it's a wrongful conviction and they're entitled to relief. And so if you, do you see how that's kind of a hybrid of the second part of your question? If you had required that complete waiver up front and then didn't get the look at the case because they didn't want to do that complete waiver, you may not be identifying cases where somebody really is entitled to relief on another ground other than actual innocence.
Thank you very much. John Martin, you're up.
Thank you. And I'll direct this question to either Larry or Patricia, and thank you both for your presentation today. We've had this ongoing debate within the Rules Commission of the Supreme Court of Ohio about whether there should be a factual basis required for a guilty plea. And I noticed that you had your statistic about the fact that there's a significant number of wrongful convictions that are coming out of guilty pleas. Should that be a procedure, or are there other procedures that you've found that can increase the efficacy of the plea procedure so as to help ensure against wrongful convictions?
Let me just say a word, and then I think Patricia will have probably better insight on this. You know, we do have to have a factual basis in Philadelphia for guilty pleas and in Pennsylvania, although generally speaking, it's, you know, with the exception of some required forensic to make out one of the elements of the offenses, generally speaking, it's just the willingness of the defendant to say, yup, that's what happened. You know, I have seen from a long career on both sides that people do plead guilty to things they never did. They do it because they do not want to face the death penalty. They do it because they do not want to face a sentence of life without the possibility of parole. They do it because they have already served time because they couldn't pay bail or they were in on a detainer. And their case is about to be continued yet again, unfortunately. And yes, it turns out defendants, you know, defense lawyers are willing to nudge their client and remind their client that they are going to have to admit to the offense in order to go through with that colloquy. And defendants often are willing to do that. You know, it's unfortunate. But I think it's probably better to have a factual basis required, but I don't think it cures it. And the truth is, even with Section 1983 civil rights lawsuits in Philadelphia for various scandals we've had involving corrupt narcotics officers, you know, some of whom were put on trial in federal court for their corrupt practices. Even in those situations, we often found that people who were innocent pled guilty because the trial tax, as they call it, the alternatives, especially if you have a draconian prosecutorial administration, or you have members of the judiciary who view the real crime as being going to trial. And we've had a few of those judges. We've had some judges who will literally give you 10 times, 15 times as long a sentence if you go to trial, even if you don't testify, even if your lawyer is 100% ethical and honorable and doesn't do anything more except remind the jury of the reasonable doubt standard. There are those judges who have always had a formula that you can do literally 15 times as much time in jail for exercising your constitutional right to go to trial, which is supposed to be a right, not a crime, than you get for the crime. So it's not an absolute protection. I think it's certainly a better practice to have a factual basis. Patricia, did you want to jump in?
Yeah, that's great. John, that's a fascinating question. And I will tell you, my experience has been in jurisdictions that I've worked in, you have to have a factual basis for a plea, or at least in a felony context, you have to have a factual basis. So I take it, obviously in Ohio, you don't. I would love to know whether or not there's been any research in the plea setting as to whether or not you see more wrongful convictions and exonerations from pleas where there was no requirement of a factual basis. I don't know if you guys are aware of that, but that's one thing that comes to my mind, kind of as a secondary part of trying to answer your question. What I think is probably most important to try to cut back on pleas where people are innocent would be an extension or an understanding that the United States Supreme Court decision in the Ruiz case regarding whether or not you have to disclose impeaching information. There's a split in the circuits right now talking about your right to get impeachment evidence is really just a due process trial right. And so you don't have to turn that over. And certainly, since it's a trial right, it's never going to be a problem in a plea. So what I'm trying to say here is that I think that we ought to have laws, policies, both, where we say that a defendant's rights under Brady, Giglio, and its progeny exist regardless of whether or not it's a plea or a trial. It's got to be turned over. And if that stuff is not turned over, there's a way in a post-conviction setting to get relief. So I look at it as those two things, at least from my studying of pleas, to be some of the most important things that we need to have in terms of tools in our toolkit.
Very good, thanks. So we have two more questions, if hopefully you have time to answer them. Assuming you still want to ask the questions. Doug, you're next up. Another good question.
Thank you. For whoever would like to answer it, Ohio has a lot of jurisdictions, just like Pennsylvania does, of greatly differing sizes. And there's a scale issue when it comes to conviction integrity units or review units. Just like not all small police agencies have internal affairs units because there just isn't a scale there to support that. In you guys' research and work around the country, have you seen different models for how that's been addressed? Whether through regional groups or through collaboratives or some other nature, other than the ones we've already discussed, obviously, as part of your presentation.
Larry, do you want me to jump into that one? Yeah, good. That question is a great one. And that is what people, let's assume that you've got an audience of folks talking about this topic, and they start with the premise that CIUs are the way to go. One of the big problems with CIUs is the recognition that they exist largely in big cities right now. And in so many states, you've got, like in Texas, for example, 254 counties, some of them incredibly rural and some big cities. And so there has been constant conversation. And let me say who's having this conversation. It's a lot of us CIU people getting together saying, how do we help the counties that don't have the resources, the money to have a CIU. And quite frankly, they're not really big enough to justify it, even if they had some money to do it. And so we are constantly trying to come up with a solution to that problem. And a couple of the kind of short-term solutions is that if, we have 75 CIUs and we're all working together, we can start really educating and training people and supporting those counties that don't have the ability to have a unit, such that you can instill in prosecutors' offices offices some of these ideals and best practices so that they could actually do the work without having their own CIU unit. Some folks say, yeah, you don't need a unit because it really is about changing the culture. Eventually we're going to get there. But the stopgap, I think now, is for CIUs to be a resource and for there to be more conversations about what it means to look at convictions to see if they have integrity. And I hope that answers your question, but I mean, it's a good one and everybody's talking about it. And I just don't think that there's a silver bullet for it right now. So we got to do the best we can.
Larry, is there anything you'd like to add as it relates to that from your, as the elected DA dealing with other DAs, officers?
Well, let me, I don't think I'm an expert on this, but I do think that there is always, when you're trying to bring change, there's always a political dimension.
Yeah.
And I think it is the case in Pennsylvania. I don't know about Ohio, but I think it's the case in Pennsylvania. It's the case in California that you sometimes have large urban centers that are more to the left, and you have rural areas that are more to the right. And often when you are dealing with a statewide prosecutor, and I say this with love and respect, often those are people who have had to run statewide, and therefore they've had to sort of tack toward the middle, and sometimes they have other aspirations that are statewide, and that's why they went there in the first place, right? So I think part of the task of dealing with the resource issues for small jurisdictions in terms of conviction integrity, where a statewide prosecutor is willing or is able to try to serve in that role or support the existence of something that would be statewide, part of the task is to show that statewide prosecutor that this is a good move politically. And it is. I can tell you that in Pennsylvania, our statewide prosecutor went that way. And he went that way as a consequence of seeing the favorable response that was coming. I mean, in my opinion, the favorable response that was coming to Philadelphia, not just from liberal or progressive people, but also from conservative people who believe in the accuracy of the system and believe in catching guilty people and releasing innocent people just as much as people do on the left. I would also note that there is considerable handholding, considerable love between a lot of conservatives and, for example, the Koch brothers, who believe our country is too incarcerated, and people who are much farther on the left who also believe our country is too incarcerated. So I think that, just in terms of moving it forward, I think that's an important aspect to it. And I recognize that in Pennsylvania, for example, a local prosecutor can call on the attorney general's office to prosecute a difficult case, a difficult homicide case, because there are some jurisdictions in our 67 counties where you really only have a chief prosecutor and nobody else. My office is 630 people, right? So there is a differential in terms of resources, and the AG's office is about another 600 or so people. So I'm making a variety of assumptions here, but I do think it's always important to keep an eye on this sort of misperception that people don't support CIUs. The people support CIUs. The question is not the people, it's whether the institutions are ready to adapt to it, including our political institutions.
Thank you very much, D.A. Krasner. So next question is from Joanna Sanchez, who is with the Ohio Public Defender's Office. Joanna?
Thank you. I was wondering if you could speak a little bit about the internal decision-making process, both at the CIU level, in terms of, do you have a panel, or Ms. Cummings, do you make the ultimate decision about the recommendation made to DA Krasner? And then once that recommendation is made, what are the internal steps that take place until there's an ultimate decision made by DA Krasner? Thank you.
So Larry, you want to jump in first, or you want me to?
I'll do the 2-sentence version. Patricia and her crew do a ton of work and stay up late doing all of it. And then she comes into my office and we drink some coffee, and then I say yes or no. I usually say yes. If I have any serious questions, and sometimes I do, or I want an additional layer of investigation, or I want them to consult with more experts, then I'll do that. But we have some pretty amazing people working in the unit, including people with very highly specialized expertise in things like biochemistry, in addition to their law degrees and their many years of experience doing post-trial proceedings. So they're really smart, they're really careful. They say no to a lot of these claims, as they should. And so they have a high level of credibility with me. If I ever felt like I needed another layer, then I would go there. But that is not how I've felt thus far.
That's an excellent answer. I love it, Larry. I'm not a believer in another layer. I'm not a believer in the boards or whether it's in the office or outside the office. And for a variety of reasons, and I won't bore you with all of them, but I will say one thing that I've learned in the unit is, these cases are so important. And when I take a case to Larry, by God, I want to be right. And so what we do internally in our unit is we have a team's approach to the case where we're trying, we're not always successful based on our workload, but we always try to have at least 2 prosecutors assigned each case. Sometimes we have 3 and 4. And the idea there is I want different ideas. I want different experiences so that we can collectively decide, is this a wrongful conviction? Is this person innocent? And when I have that and I take it to Larry, I have so much more confidence in what I'm bringing to him. And I want to say, Larry's right. I mean, I've been blessed because the people he's given me in my unit are so good, so smart, so dedicated. And I just want to give a shout out. I've got somebody from Ohio, Carrie Wood, and you guys may know her. And I don't know what I would do without her. It's that kind of commitment to the unit, getting good quality people and working together as a team. And I will say, one more thing, and then I'm going to shush. I'm not a believer in the boards, but I am a believer in having the tools to consult with people when we need to have somebody on the outside looking at it. And so we get experts, and Larry has given us the ability to have the money to hire experts. So we've hired mechanical engineers, we've hired forensic pathologists. We had, for lack of a better way to describe it right now, the jailhouse snitch academic expert in California look at a case with us. So that all is helpful. And we like to use outside people to give us more knowledge and information as opposed to supplant our ability to make recommendations and take them to Larry.
Very good. So thank you very much. Judge McIntosh, you want to know if you can ask one more question, of course, for you. But it's the last question, and we'll move on.
Well, thank you, Gene. In part, just sort of based upon what you just indicated, the resources that you have available, again, sort of towards best practices, if an office was to create the unit, I mean, what at a minimum would you say they would need? I mean, investigators, obviously resources for experts, or can a unit be viable without something like that? And then also sort of based upon both of your backgrounds, would you recommend bringing in someone with a criminal defense background as well to that unit?
Well, let me just, if I may, Judge McIntosh, let me just address the more discrete issue. Who would I recommend bringing in? I would absolutely recommend bringing in people who are very knowledgeable and who can be very independent. Yes, they may need some, baby lawyers to do research for them, but in terms of the people batting at the top of the order, in terms of the most essential people in the unit, they need a breadth of experience and they need independence. I would not recommend ordinarily taking someone who's been in the office and has established relationships with detectives and with other attorneys in the office that go back decades. I just think that creates independence issues that are difficult. Certainly, if you're lucky enough to get someone like, Patricia Cummings, who has headed another unit in another city, or you're able to get someone who has a decade with the Innocence Project after a decade as a prosecutor and a decade as a defense attorney, those would be some pretty amazing choices and people to look at. But there are certainly a lot of very, very qualified people who can fill that. I do think having ideally both prosecutorial and defense experience is helpful. I think having a wide breadth of trial experience, people who have done death penalty cases, other homicide cases, a lot of first degree felonies, people who have had 10,000 clients and 2,000 trials and a couple hundred jury trials. Those are the people who can spot the wrinkle. They can see the nuance in the transcript. They can wonder why a thing is not there, or it doesn't appear to be something that normally should have been. I think those are, they can look in a file and say, what's this? This is different. So I think that those kinds of people are really good. And very quickly, I will tell you that I mentioned the new LA prosecutor, George Cascone. For those of you who don't know, George is one of the most important progressive prosecutors in the United States, and he's a career cop. He was a beat cop in LA. He then became the chief of police in Mesa, Arizona. He then became the chief of police in San Francisco, California. When Kamala Harris was the DA, Kamala Harris goes to be the AG. And the governor appointed this man who picked up his law degree while he was being a chief of police and who had never actually gone to court, appoints him to be the district attorney in San Francisco because of the, he had been such a thoughtful and progressive police chief in San Francisco. And he was the ultimate example of someone who was after independence in terms of both police involved shootings and things of that sort. So, independence really matters, and it can probably be found with a variety of different forms of experience. But, one of the things that I love to talk about is, I think that there's this caricature of progressive prosecutors, or maybe people who do CIU work, that we all have our tie-dye t-shirts, and if we didn't go to Woodstock, we wished we did. Well, go talk to George Gascon, who has been a cop his whole life, and he's now going to be the DA in the biggest criminal justice jurisdiction in the United States. You can find great people to do this everywhere. They just have to have that real core of independence and not too many established relationships.
Very good.
Can I add something real quick? I just want to follow up. Judge McIntosh. What I would say is, ideally, you have two prosecutors, an investigator, and a paralegal. And don't be completely afraid to try to do the work if you don't have the money to hire a lot of experts, because two things I've seen, and I see it continually. One is, if you bring in two prosecutors, a paralegal, and an investigator, make sure they're creative, because there's a lot of grant money out there. And CIUs are figuring out how to get money to do a lot of the work. And even if you don't have the grant money, at least not at the outset, what I have found is you can get people, you can call up some of the best experts in the country as a prosecutor and a CIU, and you can say, I got this problem and I would like for you to look at it, but I don't have the money to pay you. Would you look at it? And I can't tell you how many times I've had people tell me yes. So it's just, you got to be resourceful and creative. And then, it's kind of like Field of Dreams, build it and they will come. Once you start doing the work and you show that you're committed to it, it's going to grow and you're going to be able to do more and more.
Let me, if I may, I know we're over, but I think that's a really important point. We have had a surprising number of academic institutions and foundations come forward to fund really important things for us because, in part, they just thought it was interesting. We're trying to do interesting stuff. But that story I told you about, the other Ted Bundy, well, the photographic work that was done to link the two socks, the one found in the body and the one found, years later on his person, that was done by a university professor, and it was done for free. We have had the Chan Zuckerberg Institute put down a few $1 million for data work that has been done. We had an amazing moment here when grant money that was put all around the country to different prosecutors to clear rape kits that were piling up and had not been cleared. Well, we finished that process. Thank God that money was given by the government a few years ago. And we identified so many rapists and sexually assaultive defendants based upon just the completion of those rape kits, that I would not underestimate the potentially tens of millions of dollars that you can attract from the government, from foundations, and also from academics, to the extent you're willing to be somewhat transparent about efforts to do things better.
Thank you very much. And with those inspiring words, we'll conclude at this point. We are a little bit over, but I think it was well worth the time. I want to express thanks and gratitude for your willingness to spend literally the morning with us. We live in precarious, crazy times with this COVID pandemic as it appears to be raising its ugliness all across this country. And yet, because of it, we're able to get you here in Ohio. a lot easier than if we did it the old-fashioned way and we would try to figure out logistics of flying you in, and we probably wouldn't have had the opportunity to be enlightened about what you're doing in Philadelphia, your perspective on this particular issue, insights that we'll take with us. I think you also got a sense of how interested and how intent we are in making sure as we move forward as a state, we're going to make those suggestions and corrections so it is meaningful, that those changes will be made in such a way that justice shall be served for every defendant, every accused. And I want to thank each of you for the amount of time that you spent in preparation of your material and your presentations here today. Well done. I wish you both best of luck. Thanks much. With that note, we're going to sign off now, but we do have the December 10th meeting that you all are aware of. And as a consequence of task force member requesting, I've been able to secure Maurice Posey, who works for the National Registry of Exoneration, and he's going to give a presentation that is specific to the data from that exoneration registry pertaining to Ohio, which is what the ask was of him. He's more than willing to do that. Now, he's out in California, so his presentation is going to be at 11, which is 8 o'clock his time, but he says he'll be willing to do that. We're still going to meet at 10. In that first hour, I think we should talk about what we have digested. Patricia has agreed, and so we will post the PowerPoint to our site on the Supreme Court website for you to review and look at. But I think there was a lot of material, obviously, and a lot of insight, and worth some time for each of us to reflect. And I'd like to take a little bit of time as before Maurice comes on at 11 to talk about what we thought, where we're headed, and then map out kind of after the holiday going January forward is how I envision doing this. Okay. Questions, anyone, before we jump? Thanks for all of your time, questions, participation. Really, really well done. I appreciate that. Thank you, Judge McIntosh in particular. So, as always, if nothing else,